Okay, we're about to get started, everyone. Welcome to this evening's presentation. Thank you for sharing your time with us tonight to learn about estate planning and legacy strategies. My name is Natalie Nahas. I'm the Senior Business Development Officer at the Los Angeles Police Federal Credit Union. This is a live webinar that you are about to watch, which is interactive and open for questions at the end of the presentation. So welcome, everybody. At this time, I'd like to introduce our presenter for the evening. We are pleased that each and every one of you could take the time out to listen to today's webinar about estate planning and the presentation. Our goal for this evening is to give you an overview of estate and legacy planning and to show you how you can use these various planning strategies to help ensure your family's future financial security. Our presenter for the evening is Mr. Chris Ellis, a financial advisor from CUSO Financial Services, who works closely with our members with their investment and retirement needs. Chris brings over 20 years of coaching and leadership experience to the CUSO Financial Services EP, and he has been with the Los Angeles Police Federal Credit Union since 2016. He graduated from Pepperdine University with a BA in Political Science in 1998 and Loyola Marymount University with a master's in 2003. Chris worked at a small independent firm for over 3 years before moving to his current role with CFS. He is able to provide insight into retirement planning, asset allocation for 401k, 403b, and 457 plans, investment portfolios, estate planning, and life insurance. So now I'd like to turn it over to Chris for this evening's presentation. Thank you.
Thank you, Natalie. Natalie, can you hear me okay?
Yes.
Perfect. Okay. Thank you all for joining us this evening. We appreciate your attendance and participation. We definitely want this to be an educational event for you. With that, we definitely want to make sure that with estate planning, when we start talking about wills and trusts or taxation, investment advice, we do have to, make sure that we disclose that this is not intended for specific legal or tax advice. Please consult a legal or tax advice specialist or an attorney for specific matters. We're definitely here to help and guide you in the right direction, but we need to make sure that we are providing that disclosure. Natalie gave you a brief background of my experience here with the credit union, as well as my experiences previously. One of the things that I like to share with people is back in 2010, 2011, I used to work for Target Corporation. Target's a great company, provided a lot of great educational resources, but one of my roles there was to provide information for the 401k, help people get signed up, provide information on the matching component. Well, many of you recognize back in 2010, 2011, it was a pretty rough time for people. And so I'm telling people to save for retirement, and at that time they couldn't even make their house payments, or they were struggling, or they knew somebody who was struggling and needed help, needed advice. So that's kind of when I decided to make a career change and go into financial planning so that I could help people be able to answer those questions. If I answered those questions while I worked at Target, Target would have been liable for everything I said. So I want to make sure that we're providing as much information as possible specific to what you need. We're going to give you a lot of general information tonight, but hopefully you'll be able to take some of that information and apply it to yourself. And something that you don't know or you need specific information on, please reach out to me, reach out to somebody that you trust that's going to be able to provide that information. Now, this is the disclosure for the financial side of things. I work for CUSO Financial Services. CUSO is owned by Atria Wealth, a top 5 independent broker-dealer here in the United States. I've been working with the credit union for almost 6 years. Early 2022 will be 6 years here. It's a great fit. I don't work with any other financial institutions. I don't work with any other banks or credit unions. I'm exclusive to the membership here at the credit union. And it's something that I do cherish, and I plan on being here for as long as they'll keep me. All right. So the agenda for tonight. Okay. So estate planning. a lot of people are confused when they start thinking about estate planning. They say, well, that's something that happens when you die. Well, hopefully it doesn't. Hopefully you've planned how to handle your estate before you pass away so that you've dictated or handled it for whatever purposes. How does this impact you? And it's going to impact each person individually. Whether you have multiple properties that you're trying to protect, you have a large financial retirement account, you have, or you don't have much, and you're trying to figure out how to leave as much as possible for your children or your beneficiaries. That's just as important as the person who's trying to protect millions of dollars, because that's something that's important to you. And we don't forget that. We want to make sure that every person is included in this format. And you'll see how that is included here within the presentation. We're going to talk about some financial planning involving your estate. Specifically, that's about taxation. How are you taxed with your estate while you're living, and when you pass away? What's that going to look like for your beneficiaries? And then what's the next steps to help protect your estate? So the first thing we're going to discuss is, if I can do this. Okay, what is an estate? Okay, an estate comprises of one's individual's net worth. Each person has their own estate. Even if you're a married couple, you each have your own estate. It is joint while you're married, but upon passing, that can be individualized, and sometimes that's important for taxation. What comprises your net worth? Well, that's going to be real estate, financial accounts at your bank, retirement, any investments. It could be physical assets. We could be looking at cars, artwork, memorabilia, coins, stamps, different types of collections. Estate planning is the process of transferring your estate to the beneficiaries. How can we set this up to make sure that it's an easy transition to whomever you want this to go to? And remember, if you don't make that decision while you're alive, the courts are going to make that decision on who gets your stuff. So control. So why do we plan? Control over these decisions. And then taxes. Taxes is going to be a big one that I focus on tonight, because specifically I'm the financial advisor in the room, and I want to make sure that you keep as much money in your pocket. I love the United States, and I know that we have to pay whatever is due, for taxes, but I want to make sure you keep more of that than give to them, because then you're going to spend it and you're going to use it for the economy. That's how I believe in how to incorporate a better economy, instead of taxes where I want to be careful about who I'm talking to, but sometimes they don't know how to spend it correctly. So those are things to just think about while we're going through this process. And there's a few other additional important information we're going to talk through. All right. So what is a trust? So we used to do a wills and trusts information night or a webinar, and what we figured out is wills and trusts are very specific to each individual. We wanted to give a more broader, comprehensive approach to protecting your estate, and looking at all of the different avenues to how to do that, and then what's right for you, what's going to be the best option. So a trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. So I want you to think of a trust as an entity. When you set up a trust and you protect your assets within the trust, it is separated from you, the individual. The entity now owns or protects your asset. That could be your home, rental properties, or bank accounts. It cannot own your IRA. An IRA is an individual retirement account, or your 401k, 457 deferred comp. Those are things that have to stay with the individual. But your trust, the entity, can own a lot of other things and help protect those. The trust is used for estate planning, what we're talking about tonight, and tax management. The most common types of trusts are revocable trusts. Revocable means that I can change it. I can revoke what I had set up, and I want to make additions or changes to that. irrevocable trust, which is typically used for protecting it against future estate taxes. But irrevocable, once you set it up, that's it. You can't change it. And then there's also special needs trust. Those are the three that we're going to focus on tonight. The additional benefits of setting up a trust for yourself is that it avoids probate. Probate is when your assets are sent to the government and the government decides through a court, right? Probate court, the court decides who is going to get your assets or who should be responsible for making the decisions. So if you set up a trust, you don't have to go through that process. You have protection, right? And that's not just protection against probate or future government. It could be a protection against creditors. It could be protection against taxation. It could be creditor or protection against fraud or default, and then control. So a trust gives you control even when you are no longer here, or if you're incapacitated. You've decided who's going to help make those decisions for you, and you've written it out. So that's the important part of this. And then lastly, it's privacy. Only the people who are beneficiaries or involved with the trust will ever know how the trust is laid out. If it goes to probate, that is now exposed so everyone can see what your assets were, how you handled your business, what type of investments. So the privacy of setting up a trust can be very important for people because they don't want that exposed to the public. All right, parties to a living trust. So we've set up this trust. The trust basically is set up by a grantor or settler. That is going to be you. That's going to be the person, or you as a couple. There's going to be two grantors or two settlers. You created the trust for your protection. The trustee is the manager of the assets. This is the person who's going to make all the decisions for the trust. At the beginning of when you set this up, the trustee is the same as the grantor settler. That's you. You're the trustee of your trust until you can no longer do that. You can choose to do that because you can't, perform that, or you don't want to. So you can just say, I don't want to do it anymore. I'm leaving that up to my spouse, or I'm leaving it up to my children, or I'm leaving it up to a friend that I trust. It happens with death. Once you pass away, the successor trustee is your backup to the original trustee. And that is the person who will step in and enforce what your trust has been set up to make sure the beneficiaries get what they deserve or they belong to. And then lastly is the beneficiaries, the recipients of the trust. So that's how it's set up. One of the things that I want to make sure people understand is the reason why trusts are not completed in this country a lot of times. So if you look at some of the stats, there are only 18% of Americans who are over the age of 55 who have a trust set up. 18% over the age of 55 who have a trust set up. But 88% of Americans believe that not having your estate planning or trust set up is irresponsible, negligent, it's irreconcilable. But there's a disconnect there. People believe it's important, but it's not urgent, or they don't understand it. It's confusing. How do I set this up? Who do I leave as the responsible party to make this? The other reason is it's expensive, right? I don't want to hire an attorney and pay thousands of dollars when I can just add people's names onto my assets and make sure that they're just going to get it when I pass away. So I understand. I've been doing this a long time. I know the reasons why people don't set up trusts. But hopefully we can get you to understand what it looks like, and then hopefully we can connect you to get this set up to protect your assets. Here are additional benefits of a living trust. Revocable and can be changed at any time. Okay, this is important. Life changes. Sometimes we get divorced, right? Or there's a change in our relationship status. We might have children that we don't want to be included in our assets anymore. And I don't want to say that harshly, but that happens. It happens constantly in our business that they don't want to leave behind the same amount, or they don't want to leave behind anything because they've lost that connection with a child or a friend or a relative. So being able to adjust and adapt is very important as well. We already talked about avoiding probate, backup name to step in and incapacity. So incapacity, this is what we call a durable power of attorney. I'm going to go into that a little bit further down the road. But a durable power of attorney says, I'm going to set up today who is going to be responsible for my financial assets if I can't do it anymore. I'm in the hospital. I'm in a situation where I'm not mentally stable anymore. I need to have this set up. And with a durable power of attorney, you get to decide your financial well-being and who's going to be responsible for that. I always use my children as an example of this. And I need to be careful because my 10-year-old daughter is listening right now. But my daughter is going to be my medical director. She is going to be in charge of any medical decisions that need to, because she is cutthroat. She can pull that plug. If I were incapacitated and I was brain dead, she'd have no problem saying, we got to pull the plug. But I'm not going to have her my durable power of attorney. I got to make sure that my son has that because he's more financially responsible with money. My daughter would spend it like crazy, and not on things that would be beneficial for me. So we can decide those two different things. And I'm joking about my kids. I love them. They're 10 and 8. They've got a long way to go to make before I can decide who that is. But it's just an example to make sure that you understand that you have control of who this is. And then, like I said, you keep control of the assets. Even if you can't make those decisions anymore, you set up in place what you want to take. And then it's protection for your heirs. If you don't set up a trust, anybody might be able to come in later and lay claim to your assets and say that, you set this partnership up at some point and it goes to court, it's additional costs. Your heirs might not get your assets if the court deems that there's something else out there or somebody else that could be the beneficiary of your properties or money. So those are some additional benefits of the living trust. Now, I'm sure there's already information. I can't see the questions in the chat, so I'm going to be not answering any questions until the end. But you're probably saying, well, I can set up a will, and a will, I don't need a trust. I can just lay out my will, and the will dictate who gets my assets and who's going to get the house and all that stuff. Absolutely. A will is a form of a legal document that communicates your final wishes, right? My dependents are going to get my assets. The money is going to go to this person. Specifics to whom assets should be distributed, guardianship, management of accounts, or the wishes. This is actually 100% true. The will absolutely do that. You could write up a will, get it notarized tomorrow at the credit union, and that will be a sufficient document to transfer your assets. But it still goes through probate in the state of California. You still have to pay court costs to make sure that nobody can contest that will. If you write a will and get it notarized, that's brilliant. You've done one aspect of protecting your assets. But who knows who was forcing you to write that will? Who knows who was putting in any communications to adjust, change, forgery? When you get a legal document that's binding in the state of California, that is a trust, that is set forth by a legal attorney, then you have full protection and it avoids probate. So those are some things that I want you to continue to think about is, yes, if you have a will, that's great, but it still could continue to go through the probate process. Now let's talk about probate for a second. I think I've got a note. Probate in the state of California, especially here in LA County, probate is on average 2.5 to 3 years long. So it will take 2.5, 3 years for your beneficiaries to get access or control of any money, accounts, house. It's going to be expensive. You're going to pay attorney fees. and that's typically going to run 1.5 to 3% of the total value of your estate. Now, I want you to stop and think about that for a second. Think about what home prices are today. Think about your retirement accounts. Think about all of your money. Think about your cars, your jewelry, every penny that you are worth. Imagine paying 3% in court costs on that. Yeah, that's tens of thousands of dollars that you will be paying in fees because you didn't get a trust, because we're procrastinators, because we're scared of the process. We don't know who to decide to be our successor trustee. I'm just not sure. Or we just don't think it's that important right now. So that's what I'm trying to get across tonight. Is I'm not trying to say like light a fire under you and be urgent to get this done, but I want you to understand the ramifications. I want you to make sure that you are, cognizant of the decisions you're making today that are going to impact your future. Now, going back to the will, these are the basics of the will. The will provides who receives your assets, how the assets will pass, when your heirs will receive the assets. Choose an executor, you're an individual, a professional. Choose a guardian for your children. Create testamentary trusts for minors or adult spendthrift beneficiaries. We'll go into that. But the will is included in your trust if you get a trust. It also has what's called a pour over will. If you look down at the bottom of this slide, we'll skip about do I need a will includes a pour over will. So, or a trust includes a pour over will. So I set up a trust and I create my beneficiaries, but let's say I forget to go to the county recorder and change the title of my property from my name or my wife or my spouse and I's name to the trust. The pour over will includes that in your trust, and it will be protected and it can still avoid probate. Okay. Now you're saying, okay, do I need a will or a trust? I've already said most Californians need a trust, but the value of your assets can help dictate what you need. Real property. Okay. If you have real property that is valued over $55,000, right? $55,425, or personal property over $166,000, then you need a trust. If it's under that, the will suffice because it doesn't have enough value that the court deems that it should have to go through probate. So it goes through what's called a small estate affidavit. So a small estate affidavit can be protected for some of your smaller accounts. A will or a trust, okay? So minor children, the guardianship. So I had an attorney tell me one time, they said, who's going to love your children as much as you do? So within the will or the trust, you can absolutely dictate your minor children who's the guardianship. But again, the will can be contested in probate. The government can step in and say, no, even though you put a will, we don't know if it was, legit. So instead of the minor children that you have going to, your mom and dad, we're going to have them go to, this side of the family or that side of the family. So a trust will supersede that. It avoids probate. Your minor children, anyone under the age of 18, you dictate who is going to love them as much as you do, or hopefully will take care of them and protect them. And, the love hopefully is there as well. All right. A trust avoids probate. We've gone through that a number of times. I'm not sure if you're aware the trust avoids probate. All right. A will is included in the trust. The pour over will feature is very important because that helps to protect any account that you forgot to change or you forgot to put a beneficiary on. So a trust will supersede that because it's a legal binding document that's accepted by the government in the state of California. All right. So a couple other trusts that I want you guys to be familiar with or to make sure you understand the benefits. If you have, I'm skipping ahead. So we already talked about minor children, spendthrift beneficiaries. That's something that's extremely specific. We'll go over that for each individual member who has questions. But the blended families is the one that we want to talk through. So I heard an attorney presented for us a while back. He used to talk about the Brady Bunch. So many of us are familiar with the Brady Bunch. You got, Mr. and Mrs. Brady. bring two families together and they get married and now they have this blended family. Well, when you have a blended family, and if one of the parents passes away, right, of that new blended family, and then a spouse remarries for a third time or again, what's going to happen to the assets that might have gone through this side of the family or through one of the deceased's children? They might not get anything because everything goes to the spouse remarries, and it goes to that side of the family. Those three kids, if it's Mr. Brady's kids, Greg and Bobby, I'm not sure who the other guy was, but they might be living on the street because Mrs. Brady, met a Mr. Sampson, and Mr. Sampson doesn't want anything to do with Mr. Brady's kids, and he kicks him out of the family. So having a trust to make sure that your assets stay within your blended family can be really important. And just making sure that you understand that you can dictate that and make sure that everyone's protected. And then a special needs person. A special needs trust is extremely important here in the state of California. If you have someone who's of special needs in your family, there might be Social Security disability, there might be other resources that are available. Well, if you, the parent, passes away and you leave your special needs child, no matter what age they are, all of these assets, and it's not protected in a special needs trust, the state of California says, oh, you got all this money now. We're going to let you spend all of your money down, and we're going to stop the benefits. And once you spend your money down to under $2,000, then we'll come back in and we'll start giving you your disability, your Medi-Cal, and the other benefits that we had been giving you before. And if the house that you left them isn't protected in a special needs trust, as it's passed down from your trust to a special needs trust, if it's not, then any additional funds that they give that your child throughout their whole lifetime, when the house gets sold, the beneficiary or the grantor, the settlor, the trustee, you still have full control over this entity. But when the money's in the entity, the state of California can't force you to spend it down. They can't access it because it's not yours. The beneficiary of that trust, the special needs trust, can access as much money as they need for themselves, and it can't be counted against them for the services that they're getting from the state of California. So these are extremely important things that you need to address. Okay, and I'm talking about these things. Attorneys and other resources to be able to complete these trusts are there. My recommendation is come talk to me first so we can get everything in order of what you need. I'm going to help organize this for you, and then we're going to connect you with the right person, whether that's an attorney or the other services that you need to make sure that you can get this completed. Wills and trusts are the #1 topic that people talk about in terms of the credit union coming in or phone calls we receive. They're always looking for information on wills and trusts. And so we're trying to figure out what is the best way to help create education and then execution, right? So if you use us as the point of contact, we'll be able to outsource that to the specific person who's going to be the best fit for you and what you need. All right. This is just a description of what are personal assets versus your financial assets. So personal assets. So physical assets are going to be your cars, jewelry, coins, stamps, art. It's really hard to write a beneficiary on each asset, right? If you collect gold coins, you're going to engrave your beneficiary's name on that? No, you're not. Instructions on how they should handle it, like something that you don't want to be sold. Maybe there's an heirloom or something that's really important and you just don't want it to leave the family. Or you want one person to, be able to live in a home for however long they want to. You don't want it sold and have that person kicked out of the house. All those things can be included in your trust. That's why I talk about control. You get to decide how you want these things handled. Financial assets. So savings and checking accounts. Have you added beneficiaries to your bank accounts? Okay, at the credit union, you have a member card, right? That member card has beneficiaries on there. You'll be shocked to know how many people don't list beneficiaries on their cards. And so then somebody comes in and they have a death certificate and they're like going, well, I'm here to get my parents' assets or my spouse's assets. And it's like, how do we know this is yours? So make sure you're taking the time to do these things. And the fact that you're listening to me tonight means that you do care enough about it. And hopefully this is, igniting you to go and take action. Within the 401k deferred comp, within the 401k and deferred comps, you should have a beneficiary, but you should also have a contingent beneficiary. We've had two clients of mine. They were also members, but the couples died in tragic accidents, and we only had the spouse as their beneficiary because one had a trust. They just never gave me the title of the trust and the date to add as a contingent. Luckily, pour over will, it was included in the pour over will, avoids probate. The other trust accounts, remember the entity owns the account for the executor, grantor, or truster. We do recommend that if you have a trust set up that you change your savings, checking accounts, all of those liquid assets into a trust account, and just make sure that that's titled correctly. There's also something called a TOD, which is a transfer on death. So folks who don't have let's say you have a Schwab account or you have an investment account with us at CUSO on the Pershing platform at the Bank of New York Mellon. We will set up an individual account for you or a joint account, but we'll also put transfer on death until you get your trust completed. Then we will change the whole title of the account to the trust. So these are some things to make sure you're aware of with your financial assets. And then who receives your assets? Well, with a trust or will, you choose who your assets are going to go to: your spouse, children, grandchildren, friends. You can choose charities. So I have a lot of people and they say, well, I'm not going to set up a trust because I don't have anybody to leave it to. I don't have any children. I'm not that close with family. So I don't know what to do. Okay, well, choose a charity, choose an organization that you might want to be leaving your assets to. There are places that you can think about that are important to you in your life that you might want to leave those to. And that's a good discussion to have, just to figure out what's important. Because again, if you don't do anything, well, then when you pass away, your estate goes into something called intestate. Okay, so intestate, it's the government's choice. They say, okay, you passed away. The first thing that the government does, and I say government, it's the court, it's probate court. The judge is going to say, do you have any parents alive? Okay, the court goes up first and says, if you have any parents alive. And then if your parents are passed away, right, then they look down and see if you have any children. Okay, and then if there's no children, then they'll look sideways and see if there's siblings. All right. So it's a pretty simple, it's kind of like if you were religious, it might be like doing the sign of the cross. But it is an arbitrary reason why they're choosing who they are to leave your assets to. Because you might not have any relationship with a parent. But if they're alive and they're the only parent alive and you haven't spoken to them in 30 years, they could still get all of your assets because the court doesn't care, right? A famous case is James Dean. When James Dean took his car flying off Malibu Canyon, but I went to Pepperdine, so Malibu Canyon, we were always worried about that road. But when he lost his life, he hadn't spoken to his father pretty much his whole life. His mom had left his dad when he was a child, no relationship, but he was the only living spouse. And that father got everything of James Dean's because it wasn't there. And this is funny because this morning, maybe some of you guys were watching William Shatner fly into space, which is pretty amazing. For a 90-year-old man, I got to give him props. But I bet you before he got on that rocket this morning, he had his affairs in order. He had his estate plan checked. He had his trust or will, whatever he's got going on. You know, all of those things were in line to make sure that those were addressed before he launched into space. Because his family was probably worried, hey, who knows what's going to happen? Is he going to make it back? So it's very impressive, but use that as a catalyst to say, if we were going to go to space tomorrow, what would we be doing today to make sure our affairs are in order? Well, we don't know if we're going to go, well, most of us know we're not going to space tomorrow, but are we going to end up going to, the hospital? We have a pandemic. People are, getting intubated because of COVID. Car accidents. People are losing their life on a daily basis. All kinds of tragedies are happening. So take action now so that your future is protected for your beneficiaries, the people that you care about. Why should I avoid probate? I think we've kind of got covered over this. Second. Okay, here are some substitutes for a will and trust. So specifically, joint ownership. So husband and wife, joint owners with rights of survivorship. That means if one person dies, it automatically goes to the living spouse. Okay, and you can set that up, a joints with rights of survivorship with pretty much anybody you want. But let's say you have a business partner, or you have somebody that you own a property with that is not somebody that you want to inherit your side of, the money. Joint tenants in common is the way to set up that. So joint tenant in common means that we're common, we know each other, but my half is my half, your half is your half. And so when I pass away, my half goes to my beneficiaries, your half goes to your beneficiaries. So that's something to consider if you are in some type of joint ownership with somebody. Beneficiary designation, I think we talked about that. Life insurance policies, your retirement accounts, bank accounts. Typically, a lot of the major banks don't have beneficiaries in place. They probably won't even do a transfer on death for you. So you really need a trust to change the title of the account. But for all credit union members, stay with credit union. It's good for you. And then transfers on death we just talked about. All right, now here's the power of attorney part I was talking about before, the medical directive, durable power of attorney. Now, this is while the person is still alive, but they're not able to make the decisions for themselves. Power of attorney says that a spouse, a child, some other caretaker has this power to control your assets, to make those decisions financially for you. Once you pass away, the power of attorney is no longer in existence. Power of attorney is only for somebody who's alive. Once they're dead, you don't have power anymore because there's nothing to have power over. So that's when the trust kicks in, and then the successor trustees will decide what's going to happen with your financial assets. Springing power of attorney, this is when you take control, you keep control until it's needed. Once the person becomes capable of managing their own assets again, then they manage their assets again. So that's what we call springing power of attorney. So it'll spring into action when needed, but then it'll drop back when it's not needed anymore. And then advanced healthcare directives, living wills. This is basically your who's going to make the decision for the healthcare responsibility. A lot of times when you go into the hospital, you're going for a surgery, you might be going under. The hospital will have you write something and empower somebody, but that can be contested in court. So that's when the trust, or having a advanced healthcare directive, medical directive as part of your trust kind of helps to protect and make sure that that's a legal binding document. All right. Okay. How often should you review your estate? Well, whenever there's major changes, when there's births, deaths, marriages, divorces, if you're moving out of state, I keep talking about the state of California. That's where the majority of us live. And I apologize if you're tuning in from another state. Give me a call. We'll talk about what your state dictates. But each state has their own rules regarding probate, your assets, beneficiaries. And so you need to make sure that you're connecting with somebody that's capable of giving you good advice for that specific state. Changes in estate makeup, moving from one house to another, or adding additional assets, changing your accounts from one institution to another. Those are things that are important. Business changes. There are a lot of folks who either own their own business or they have a side business. So you want to make sure that that business is protected, because if you don't have it included in some direction of who's going to have ownership of that once you're no longer here, business dies with you, right? Somebody might be able to try and keep it on, but they're literally starting it over again. They're with a change of ownership. And hopefully they would be the rightful owner of that. It might get contested in court. So having some type of estate, that might not be through a trust, that might be through something else, but we can kind of help dictate what that Articles of Confederation look like for your business, and be able to help guide you in that capacity. And then tax law changes. The tax law changes are going to be really interesting. So right now I keep talking about, just protecting your assets. For estate planning purposes, and the reason why a lot of people think estate planning is for the rich, is if you have a lot of money, when you die, the government is going to tax anything above a certain threshold at a 40% tax rate. Right now, that threshold is per person $11,750,000. The majority of us do not have that kind of wealth. In 2020, that's expected to change down to $5 million per person. So spouses, that's going to be $10 million for each. If you pass away in 2020, it's going to be $11,750,000 for you. Whatever year a spouse or a parent or a loved one passed away previously, you can look back and see what the estate tax rate was. Back in the 90s, early 2000s, we're talking about a $600,000 threshold. If you had $600,000 worth of assets, you were taxed at 40% estate tax. Okay, so we've gone up exponentially so quickly. In 2018, with the Tax Cuts and Jobs Act that was passed, it raised it up to, at that point, it was $11,250,000. It's continually gone up based off of inflation. But under the Biden administration, the expectation is this will drop back down to where it was in 2017. In 2017, it was at 5.5 million. So 5 million, you're like going, oh, I don't have 5 million. There are some of you out there that have multiple properties. Property values are extremely high right now. The other thing that you might have is your retirement assets. You might have other investment accounts out there, cryptocurrencies, whatever it may be, that have driven up your values. If you pass away, these are things to address and make sure that you have these protected, and it's very intricate. For the majority of us, and I'm including myself, we do not qualify for that. But it's something to be aware of because you never know what will change and how tax laws can change or implicate your futures. And I've said this a couple times, right? So protecting your assets now and for the future. The decisions you make today impact your estate for tomorrow and beyond. How your heirs are going to inherit your stuff. If you're not worried about it, well, then don't worry about it. Don't do anything. Don't take action. It's fine. If you are worried about it, let us help you to kind of guide you through the process. This isn't for everybody. I tell everybody my financial planning style is like going to the supermarket. When you go to the supermarket, you don't buy everything on the shelves. You go through each aisle, you pick what you need. I need some pickles for the hamburgers that we're going to make. I need some ground beef for the hamburger. I need the buns. I don't need hot dog buns because we're not doing hot dogs this time, right? You don't take everything off the shelf. So pick and choose the things that are going to make sense for you out of this and give us a call. We'll be able to help you. Skip that slide. All right, so now let's talk about the taxes. I just talked about the 40% estate tax that could be passed on to your estate if you have a high enough threshold. With this one right here, I want you to focus on the middle of the slide. We talk about long-term capital gains. The rest of the stuff, it's important, but the long-term capital gains is specific to your home. I want you to think your home, if you're a homeowner, and I bought my home for $100,000 back whenever I did, and it's worth $1 million today because the stock or the housing market has gone skyrocketing. Once that has been skyrocketed, right, $1 million, oh my gosh, I've got $900,000 worth of gains in my property, okay? If I sell my home today and take that $900,000 of profit, I'm going to have some tax protection. I'm going to have some tax protection of $250,000 per person. So if me and my spouse sell our house, $500,000 of that is protected. I'm going to pay long-term capital gains on $400,000. That could be anywhere from 15 to 20%. The 3.8% is a Medicare surcharge that they charge you once you get to a certain threshold. So you could pay as much as 23.8% on that $400,000 of gains. I don't want to do that. Remember, I love the government. I don't want to give them my tax money. So what do? Well, if I hold this property and I put it in my trust and protect it in my trust, okay, and I put my kids as my beneficiary, when I pass away, my kids are going to get what's called a step up in cost basis. They're going to inherit the house at today's market value. That's $1 million, right? When they sell it for $1 million in 3 weeks, because that's how fast houses are going, how much do they owe in taxes? 0. They owe nothing because that's the way the real estate step up in cost basis works. They won't owe anything. They inherit it through my trust at today's market value. Well, I don't want to get a trust. I don't want to go through the hassle, or I just forgot, I procrastinated. I don't want to do it. Okay, no problem. I'm going to put my kid's name on the property. I'm just going to go to the county and just add my 2 kids' names on the title of the property. Okay, no problem. The house will pass to them, right? It avoids probate because they're the owner of it. But let's say you pass away and then they want to sell the house. Okay, now they want to sell the house in the year they inherited it, right? Well, it hasn't been their primary house. They don't get any tax protection. They don't get the $250,000 per person, right? So now they sell it for $1 million. They inherited it at $100,000, which you spent on it. They didn't get a step up in basis because they're the original owner. That's how the state of California sees it. So when they sell it, they're going to owe long-term capital gains on $900,000. So let's just make it an even 20% that they owe. That's $180,000 they're going to give to the state of California. And then the surcharge of 3.8%, let's round that to 4%. That's another $36,000. So they just lost $215,000 to taxes on the $900,000, as opposed to paying 0 in taxes because it went through the trust. those are the tax ramifications. That's the biggest one that we can talk about to help you understand the differences and make sure that you take some action, see what's going to be best for you and your family. Okay, we're starting to get short on time. Skip ahead, going through this. 529 college savings plans are a way to avoid estate taxes. It helps put money away for your grandkids. You still remain control, but just going to go down here. So the last thing I want to tell you is not only can we help you with the financial or the protection of your assets through the trust, when we go through a financial planning process at the credit union to help the members, we complete what's called a Money Guide Pro analysis. This is a financial planning tool. What it does is it helps us list all of your assets, says what are your goals with your assets, who do you want to be the beneficiaries, but it also will say, can you afford your retirement? Can you afford the things that you want to do? Purchasing more properties, becoming a real estate mogul, whatever that may be. But whatever your goals are, we can kind of help you, and it'll compute a score that says, hey, based on when you want to retire at the age of 65, if your living expenses around $60,000 per year, your healthcare costs might be 18 grand per year. Travel, I want to spend 7-8 grand per year. I still have Sarah that's got to go to college. Can I afford retirement? This is something that we can do for all of our members, and we don't charge for this process. So I do recommend that everybody take advantage of it. You could go to some other financial advisors. They'll charge you $2 grand, $2,500 to complete one of these. This is something that's complimentary, being members of the credit union. And this will help you as well identify what are the assets that you need to protect, and is a trust or a will or just adding your children onto your title of your property the best road for you. So those are some things to think about. Okay, we're going to address some of the questions right now. We also can, with many of the officers out there that are paying attention tonight, drop pension, pretty much know all the ins and outs of the pension, the drop account, your deferred comp with FOIA. So if you need any special assistance or questions about how I should be allocated right now, what's the market going to look like, that's not what this topic is about tonight, but I can answer those questions if you reach out to me directly. Okay, so going to the questions. A couple questions here. I have 5 properties and I've put a child on each property. How will that work for estate planning? Okay, so that's really specific for one individual. But I'm going to get rid of, stop sharing my screen. See a little bit better. Okay, with this in particular, what I want you to think about is, excuse me, sorry. I got my kids to stay quiet for as long as I could, but they're unraveling. If you think about it, each kid might not get the same amount of money or get the same benefit, because some of those tax consequences are going to be different. Some of those property values are going to be different. So with that, there could be, it might not be fair if you're looking for fairness. But that's something you should definitely reach out to me. Let me know, if I can provide any specifics for you. We retired and moved out of state. Should we? Okay. We retired and moved out of state. Should we update our trust, or is it better to write a new one? You probably can just update it. Depending on which state that you move to, you can reach out to a local attorney, let them know what you did. They might try and upsell you and charge you for a whole new one, but depending on what state you move to, shoot me an email or give me a call, and we'll be able to connect you with somebody that might be a trusted partner in that area that can provide you that update or that information. Are there fees to speak with you? I take cash only. I'm just kidding. No, there are no fees to speak. It's always complimentary. I tell everybody the advice is free. Once we start managing assets, we start doing investments for you, that's when the fees get involved. We always fully disclose what those are. It's it's pretty fair. I don't have any overhead. The credit union pays for my office, my computer, so we pass on that discount to you guys. But we're capable of doing everything that any financial institution offers. I own property with a joint tenant with an ex-boyfriend. Can I put my half in a trust, or is it too late to change? Not too late to change. Give me a call, reach out. I'm going to share with you the last slide. Good evening, came in late. Would you mind providing the contact information again, please? Going to do that. All right, let me share the PowerPoint one more time so that you guys can get my contact information. And I want to be respectful of everybody's time. I greatly appreciate you guys listening. Hopefully there was some value there. If there is anything that you need, that's my direct phone line to the office. That's my email address. Email is better. It goes directly to the cell phone. But I will be in the office tomorrow to be able to answer any specific questions that you have. Thank you all for attending tonight. We do appreciate it. And if there's any feedback or any information that you felt needed to have to be addressed differently, or you'd like more information on, let us know so we can provide future information on those types of topics. Thank you again, everyone. Greatly appreciate it.